Good day. Welcome again to another lecture on the basic Philippine Law and Jurisprudence channel. Our topic for today is paternity and filiation. We are still in the continuation of the series of lectures on persons and family relations. Okay, so let us start with filiation. Okay, so what is filiation? Filiation is actually the relationship of the child to the father. Okay, so there are different kinds of filiation. It may be by nature or by adoption. Okay, um, if it is by nature, okay, it may be further classified into two: legitimate children or illegitimate children. Okay, now in recent jurisprudence, they are now considered as marital or non-marital children as opposed to legitimate or illegitimate. Now, there is a presumption that is provided in the law stating that if the child is conceived during the coverture of the marriage, okay, they are presumed to be legitimate. Now, it is incumbent upon the one alleging the contrary, which is usually the father or his heirs, to establish or to challenge the legitimacy through any of the grounds provided under the law. Okay. There are also the so-called uh, assisted reproduction. Okay, children conceived through assisted reproduction. Okay, so in our technology, scientific technology nowadays, okay, we have the so-called children conceived through artificial insemination or children conceived through intravenous fertilization or IVF. Okay, now the family code has provided a provision, okay, with respect to children conceived through artificial insemination. But there is still no provision in our laws regarding children conceived through in vitro fertilization. Now, with respect to artificial insemination, Article 164, Paragraph 2 states that children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife. There is only one condition: both of them authorized. So meaning before the artificial insemination is conducted, they have already authorized it or has given their consent to it before the procedure or ratified such insemination. So the consent can also be given after the procedure was done. Okay, or ratified such insemination in a written instrument executed and signed by them before the birth of the child. So the instrument shall be recorded in the civil registry together with the birth certificate of the child. Okay. Now, if there is a presumption of legitimacy with respect to children conceived during the coverture of the marriage, there is also a presumption of illegitimacy with respect to children conceived and born outside of a valid marriage. Okay, so under Article 165, children conceived and born outside a valid marriage are illegitimate unless otherwise provided in this code. Okay, so paternity is different from filiation. Paternity is actually the relationship. It is the civil status of the father to the child. Okay, while filiation is the civil status or relationship of the child to the father. So they are like mirrors, okay, facing each other but in different directions. Okay, so paternity is the establishment of the father's relationship to the child, while filiation is the establishment of the child's relationship to the father. So we will first discuss paternity. Okay, what is the best evidence of paternity or filiation? Okay, the best evidence is the birth certificate. It is prima facie evidence of filiation, and it enjoys the presumption of regularity. How about baptismal certificate? It establishment the administration of the sacraments, but it cannot. It is not a competent evidence of the child's paternity. Okay, no. Now the law provides limited grounds. Okay, for challenging the legitimacy of a child. Okay. So there are only very few grounds or uh, basis to impugn legitimacy. So the legitimacy of children conceived during the term or coverture of the marriage, okay, can be challenged only on the following limited and exclusive grounds. Okay? First, it is physical impossibility. Physical impossibility for the husband to have sexual contact with the wife within the first 120 days of the 300 days which immediately preceded the birth of the child. So we're talking here of physical impossibility. A classic example would be if, for example, the husband is working abroad, okay, and he is on the other side of the world, and therefore it is impossible for him to have sexual contact with his wife during the first 120 days of the 300 days which preceded the birth of the child. Okay. Second is the physical incapacity of the husband to have sexual contact with the wife. So, for example, he is impotent, so he is not capable of consummating the sexual act. So that is also one of the grounds. The fact that the husband and the wife were living separately. So separation de facto. So for example, if the spouses are estranged to one another, they are not on speaking terms, so it is impossible for them to have sexual contact. Serious illness of the husband, which prevented sexual intercourse. So, for example, if the husband is in a comatose condition, okay, so it prevented the sexual contact. So, if it occurred within the first 120 days of the 300 days immediately preceding the birth of the child, then it is also a ground for challenging the legitimacy of the child. Okay. Uh, it is proved for biological or other scientific reasons the child could not have been that of the husband. Okay. So when we speak of biological or other scientific reasons, we are also talking of DNA evidence. As we will discuss in the recent cases on this issue, okay, scientific evidence was considered by the court, okay, to successfully challenge the legitimacy of children. Okay. And in cases of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. So if there are vices of consent, okay, to the AI procedure, okay, then that can also be a ground to challenge the legitimacy of said child. Okay. Article 167 tells us that the child shall be considered legitimate, although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. So, if, for example, the mother is saying that uh, that child is not legitimate because it is her child with another man. Okay, that would not be a ground. Okay, that will constitute a challenge to the legitimacy of the child which was conceived during the marriage. Okay? While because of Article 167. So the legitimacy of the child was not made to depend upon the whims and caprices of the mother, because the mother may declare that the child is illegitimate, okay, for reasons only known to her. So that the law considered it as not a sufficient ground to challenge the legitimacy of the child. As long as the child was conceived and born during the term of the marriage, he is presumed to be legitimate. And his legitimacy may only be challenged using any of the grounds provided under Article 166. And the challenge of the mother, or the statement of the mother that against the legitimacy of that child, is not considered as a sufficient ground to impugn the legitimacy of that child. Okay. Article 168 also provides for a presumption in cases when the mother got married within 300 days after the termination of the previous marriage. Okay, when we speak of termination, it may be death, it may be annulment, it may be declaration of nullity. Okay, if the marriage is terminated and the mother contracted another marriage within 300 days after the termination of the former marriage, this rule shall govern in the absence of proof to the contrary. A child born before 180 days after the solemnation of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. Okay. Number two, a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. But remember, Article 168 is only a presumption, meaning if it is proved under our age or under our age and time DNA evidence, which provides 99.9 accuracy with respect to identification of paternity. Okay, this presumption must give way to scientific evidence. Okay, so the rules provided under Article 168 is only a presumption. Okay, it may be disproved, okay, by any of the grounds under Article 166, including DNA evidence. Okay, so now if we know the grounds for impugning uh, the legitimacy of children conceived during the coverture of the marriage, okay, who are the persons who are entitled to challenge the legitimacy of children, or who may impugn filiation and when? Okay, Article 169 tells us that the legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. So Article 169 is the continuation of Article 168. Okay, so if a child is born 300 days, more than 300 days after the celebration of the subsequent marriage, then whoever alleges the legitimacy or illegitimacy will have to prove it. Okay. Article 170 tells us when the action to challenge the legitimacy of children must be brought. Okay, it must be brought within said periods, otherwise they are deemed waived. Okay, or they are deemed to have prescribed. Okay. The action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register. If the husband or any of his heirs should reside in the city or municipality where the birth took place or was recorded. So 1 year from the actual birth or from the registration of the child. Okay? If the husband or his heirs do not reside at the place of birth, the period shall be 2 years if they should reside in the Philippines and 3 years if abroad. If the birth of the child has been concealed or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or the fact of registration of said birth. So 1 year if the husband or his heirs reside in the same city or municipality of the place of birth of the child, 2 years if within the Philippines, and 3 years if abroad. If there is concealment of the birth of the child, the period shall run from the date of discovery of the birth of the child or the fact of the registration of said birth. Okay. So when, as a general rule, it is the husband who is given the right and authority to challenge the filiation of children born during the marriage. However, in certain instances, the law grants also the heirs of the husband the right to challenge the legitimacy of the said children. So, Article 171 provides for the instances when the heirs of the husband may impugn the filiation of the child. Okay, first, if the husband should die before the expiration of the period fixed for bringing his action, so either 1, 2, or 3 years, if he dies before the expiration of the said period, then his heirs may bring the said action. Okay, if the husband should die after the filing of the complaint without having desisted therefrom, there is already a complaint which is filed, but during the pendency of the complaint, the husband died. Okay, and third, if the child was born after the death of the husband. So in cases of a posthumous child, okay, so the heirs can bring the action to impugn the filiation. Okay, we have the case of Jeronimo versus Santos. Okay, so the thing that we should consider, okay, in cases in determining whether or not uh, the suit is an action to impugn filiation is, okay, there has to be a challenge on the legitimacy of the child. If you are challenging not the legitimacy of the child, that but you are saying or you are contending that the child is not the child at all of the couple, okay? Not regarding his legitimacy. You are not challenging, you're not questioning the legitimacy, but you're only questioning the blood relationship, meaning that that child is not a child at all of the couple, then Article 166 will not apply. Okay? So it need not be, because it is required to challenge the legitimacy of a child born during the marriage of the couple to file a direct action, to impugn or to question the legitimacy of that child. Now, if you are not questioning the legitimacy of that child, but you are saying or you are contending that that child is not the child at all of the couple, okay, then you can bring it or you can raise it as a defense or you can raise it as one of your arguments in a suit which is not intended directly to question the legitimacy of that child. Because you're not questioning the legitimacy. You're only saying that that child is not the child at all of the couple. Okay, so in this case, Karen was claiming that he is the only child of Rufino and Caridad in a complaint for annulment of document and recovery of possession against the defendants, Geronimo, who are the brothers of her father. So we have here a child which is conceived during the marriage of her parents and her uncles. Okay? Karen discovered that the defendants executed a document entitled extrajudicial partition of a property. Now, the defendants denied the allegation that the plaintiff was the only child and sole heir of their brother. They disclosed that the deceased Rufino and Caridad were childless and took in as their ward the plaintiff who was in truth the child of Caridad's sister. So, the uncles, contending that they are the only heirs of their brother, okay, executed a deed of extrajudicial partition and challenge or question the right of Karen to inherit from her deceased parents on the ground that she's not actually a child but only a ward which was taken by the couple without the formal proceedings of adoption. Okay. Uh, how did the court rule? Okay. In this case, the filiation of a child is not an issue. Petitioner does not claim that respondent is not the legitimate child of his deceased brother Rufino. What petitioner alleges is that respondent is not the child of Rufino and Caridad. So Article 170 of the Family Code, it is not applicable because this is not an action to impugn the legitimacy of a child, but an action to claim their inheritance as legal heirs of their childless aunt. They do not claim that petitioner is an illegitimate child of the deceased, but that she is not the decedent's child at all. So Article 166, which is the grounds for impugning the legitimacy of children conceived during the marriage, will not apply. And also the requirement that legitimacy must be questioned in a direct action filed for that purpose. So in this case, this is an action for annulment of document. What is that document? The extrajudicial partition executed by the uncles. Okay, so they may raise it as a defense, okay, in that action, okay, which is because it is not the they are not questioning the legitimacy of Karen. They are saying that Karen is not the child at all of the couple. So the issue here is inheritance, and considering that he is not related in any way to the couple because she is only a ward, okay, which the couple took care of without undergoing the proceedings for legal adoption. Okay, he is not an heir at all. So he has no right to inherit at all. So Article 166 will not be applicable to this case. Okay. The case of SSS versus Aguas. So the important thing to remember in SSS versus Aguas is the right of the father to question the legitimacy of a child during the marriage. That right is personal to the father, and it is only the father or his heirs in certain cases were given authority by the law to file an action to impugn the legitimacy of children conceived during the marriage. So, in this case, Pablo's surviving spouse, Rosana, filed a claim with the SSS for death benefits. Okay? In her claim, she indicated that Pablo had a child with her, okay, during the marriage. Okay? However, During the pendency of the said claim, SSS received a letter from Leticia, who is Pablo's sister, okay, contesting Rosana's claim. She alleged that Rosana abandoned her family more than 6 years before and lived with another man. So, Leticia, the sister of Pablo, claimed that Pablo had no legal children with Rosana. So remember, uh, Leticia is the sister of Pablo. Okay. SSS therefore denied Rosana's request to resume payment of their pension. Okay, so how did the Supreme Court rule? Uh, there is no presumption more firmly established than the presumption that children born in wedlock are legitimate. This presumption becomes conclusive in the absence of proof that there is physical impossibility of access between the couple within the first 120 days of the 300 days preceding the birth of the child. Okay. Upon the expiration of the periods provided for the bringing of this action to challenge the legitimacy, the action to impugn the legitimacy of the child will no longer be feasible, and the status conferred by the presumption becomes fixed and unassailable. Impugning the legitimacy of a child is strictly a personal right of the husband, or in exceptional cases, his heirs. In this case, there is no showing that Pablo challenged the legitimacy of Jaylin during his lifetime. Hence, Jaylin's status as a legitimate child of Pablo can no longer be contested. So the moral of the story in the case of SSS versus Aguas is that it is strictly a personal right of the father to challenge or question the status of the legitimacy of a child conceived during the marriage. And it must be brought within the period provided under Article 17. If the said period has lapsed and there is no challenge on the legitimacy, the presumption becomes fixed, conclusive, and it becomes unassailable. Okay, Angeles versus Maglaya. So in this case, the issue is whether or not the respondent is the legitimate child of decedent Francisco Angeles and Genoveva Mercado. Okay. The important thing to remember in Angeles versus Maglaya is before the presumption of legitimacy comes into operation, before you can apply that, you must first prove the existence of a valid marriage between the parents. Okay. A legitimate child is a product of and therefore implies a valid and lawful marriage. Remove the element of a lawful union, and there is strictly no legitimate filiation between parents and child. So it is a condition prerequisite. Okay, you must first prove that there is a valid marriage between the parents, and you also have to prove that the child was born during the coverture of the marriage. So once these two facts are proved, automatically the presumption of legitimacy will come into operation. Okay, a child is presumed legitimate only if conceived or born in wedlock, and the presumptive legitimacy of such child cannot be attacked collaterally. So in this case, save for respondent's assertion and an entry in her certificate of birth, there is absolutely no proof of the decedent's marriage to respondent's mother. No marriage certificate or marriage contract was presented or offered in evidence. Absent such marriage, there is no presumption of legitimacy. Okay? The birth certificate was not signed by Francisco, against whom legitimate filiation is asserted. Jurisprudence teaches us that a birth certificate to be considered as validating proof of paternity must be signed by the father and the mother jointly, or by the mother alone if the father refuses. Legitimate filiation is a matter fixed by law. It cannot be made dependent on the declaration of the attending physician or midwife, or that of the mother of the newborn child. For then, an unwed mother, with or without the participation of a doctor or midwife, could veritably invest legitimate status to her offspring through the simple way of writing the putative father's name in the appropriate space in the birth certificate. Okay? Liao versus Liao. Okay. In this case, the petitioner, represented by his mother Corazon, filed an action for compulsory recognition of the illegitimate child of the late William Liao. Okay? Corazon is married but living separately from her husband, Ramon. Now, Corazon cohabited with William, were a child. Herein petitioner was then conceived and born. So we have here a child which was conceived during the coverture of the marriage, because although Corazon is estranged from Ramon, okay, their marriage has not yet been dissolved, annulled, or declared a nullity. So the marriage is still subsisting. But Corazon had a child with another man, William. Okay. Now the issue is, may the petitioner impugn his own legitimacy to be able to claim from the estate of his father, William Liao. Okay, so you must remember that the law gives the right to challenge the legitimacy of children conceived during the marriage to the father only, or to his heirs. The mother cannot declare against the legitimacy of children conceived during the marriage. Now, can the child itself, can the child impugn or challenge his own legitimacy to claim inheritance from his rich biological father? Okay, now the Supreme Court said in the case of Liao, which is a 2002 case, the presumption of legitimacy of children does not only flow out from a declaration contained in the statute, but is based on the broad principles of natural justice and the supposed virtue of the mother. The presumption is grounded in a policy to protect innocent offspring from the odium of illegitimacy. The presumption of legitimacy, however, is not conclusive and may be overthrown by evidence to the contrary. The fact that Corazon had been living separately from her husband, Ramon, at the time the petitioner was conceived and born is of no moment, while physical impossibility for the husband to have sexual intercourse with his wife is one of the grounds for impugning the legitimacy of the child. It bears emphasis that the grounds for impugning the legitimacy of the child mentioned in Article 255 may only be invoked by the husband or his heirs in proper cases. Impugning the legitimacy of the child is a strictly personal right of the husband or his heirs, for the simple reason that he is the one directly confronted with the scandal and ridicule which the infidelity of his wife produces. And he should be the one to decide whether to conceal that infidelity or expose it in view of the moral and economic interest involved. Outside of these cases, none, even his heirs, can impugn legitimacy that would amount to an insult in his memory. It is settled that a child born within a valid marriage is presumed legitimate, even though the mother may have declared against its legitimacy or may have been sentenced as unadulterous. So because in this case, the petition was filed by the mother as well as the child. Okay? A child which was born within the coverture of the marriage is challenging his own legitimacy to be able to claim inheritance from his rich biological father. So even though the mother has declared against the legitimacy of her child, okay, the Supreme Court said they have no right. The child as well as the mother cannot file an action to challenge his own legitimacy. Why? Because it is only the father, or in exceptional cases his heirs, who has a personal right, an exclusive personal right to challenge or to file a petition challenging the legitimacy of the child. If the husband does not impugn the legitimacy of the child, then the status of the child is fixed, and the latter cannot choose to be the child of his mother's paramour. If the presumption of legitimacy is overthrown, the child cannot elect the paternity of the husband who successfully defeated the presumption. Okay, again, Liao is a 2002 case. Okay, we will later on, when we go to the other cases, we will see the development in jurisprudence regarding the challenge on the legitimacy of children conceived during the marriage. Okay, we have the case of Lagabala. This is Lagabala versus Santiago. The case of Lagabala is similar to the case of Geronimo versus Santos. That if your purpose or aim is not to question the legitimacy of the child, but to assert that that child has no right to a certain property because he is not the child at all of the couple, then the provisions of Article 166 and 170 of the Family Code will not apply. There is no requirement for that suit to be brought in a direct proceeding, and there is no requirement that that challenge be brought by the father or his heirs only. Okay, so the issue in this case is whether or not respondents may impugn petitioner's filiation in this action for recovery of title and possession. So this is a case involving recovery of title and possession of a parcel of land. Okay. It contemplates situations where a doubt exists that a child is indeed a man's child by his wife and the husband denies the child's filiation. It does not refer to situations where a child is alleged not to be the child at all of a particular couple. The present case is not one impugning petitioner's legitimacy. Respondents are asserting not merely that petitioner is not a legitimate child of Jose, but that she is not a child of Jose at all. Okay? We find petitioner's silence concerning the absence of her birth certificate telling. It raises doubt as to the existence of a birth certificate that would show petitioner to be the daughter of Jose and Esperanza. Her failure to show her birth certificate would raise the presumption that if such evidence was presented, it would be adverse to her claim. Remember that for the presumption of legitimacy to apply, you have to prove two things. First, the existence of a valid marriage, and that the child was born during the subsistence of the marriage. It is only when those two facts were proved that the presumption will come into operation. Without the proof of those two facts, the presumption cannot apply. Okay? We have the case of De Jesus versus Estate of Dison. Okay, upon the death of one, petitioners born during the marriage of Danilo and Carolina were recognized in a notarized document by one as his own illegitimate children with Carolina. Okay. Based on this notarized acknowledgement, the petitioners filed a complaint for inventory and counting of the Dison estate. Okay. Now the respondents filed a motion to dismiss, alleging that the case, while denominated as an action for partition, would call for the alteration of the status of petitioners from being the legitimate children of spouses Danilo and Carolina to instead the illegitimate children of Carolina and Juan. So, how did the Supreme Court resolve this? Okay, scrutiny of the records would show that petitioners were born during the marriage of their parents, and that is Carolina and Danilo. Okay. Uh, the certificates of live birth would also identify Danilo as being their father. There is perhaps no presumption more firmly established than the presumption that children born in wedlock were legitimate. So the presumption of legitimacy fixes a civil status for the child born in wedlock, and only the father, or in exceptional cases, the heirs, can contest the legitimacy of a child born to his wife. Okay. So in this case, paramount declaration of legitimacy by law cannot be attacked collaterally. This case, it is an action for partition, one that can only be repudiated in a direct suit, specially brought for the purpose. Okay? We have the case of Lagabala versus CA. Badwa versus CA. The spouses, Vicente and Isabel, own various properties. Now, Isabel died and followed by her husband, Vicente. Okay, now the respondents, Victoria, Vicente's sister and nephew, instituted an action for issuance of letters of administration of Vicente's estate. Badwa opposed the petition. Badwa alleged that she is the sole heir of Vicente and therefore should be appointed as administrator. Okay. Like in the case of Jeronimo versus Santos, this case involves a situation where a husband denies as his own child of his wife. It is the husband who can impugn the legitimacy of said child. 170 and 171 of the Family Code speaks of the prescriptive period within which the husband should file the action to challenge the legitimacy. In the case of at bar, it is not one where the heirs of the late Vicente are contending that petitioner is not his child by Isabel. Rather, their submission is that petitioner was not born to Vicente and Isabel. So, like the case of Jeronimo, okay, the issue is not the legitimacy of the child, but his relationship, blood relationship to the couple. Okay, in which we allege to be an heir. Okay, uh, the Entrampas case, the case of people versus Entrampas. A public document, such as a birth certificate, generally enjoys the presumption of regularity. As a public document, a certificate of live birth enjoys the presumption of validity. It is not for the owner of the birth certificate to prove the facts in his certificate of live birth, but for the petition or assailing the certificate to prove its falsity. In fact, when we go later to filiation, a birth certificate is one of the primary evidence to establish filiation. Okay, Salas versus Matusalem. Okay, in this case, the important thing to remember here is the what is meant by physical impossibility. So in this case, Annabel filed a complaint for support against Narciso. She claimed that petitioner is the father of her son, Christian. However, Narciso denied paternity of Christian. Okay. What was presented as evidence? The certificate of live birth of Christian. But the same was not signed by the putative father, Narciso. It was only Annabel who filled up the entries in the certificate of live birth. The Supreme Court said that a certificate of live birth identifying the putative father is not a competent evidence of paternity when there is no showing that the putative father had a hand in the preparation of the certificate. Reviewing the records, we find the totality of respondents' evidence insufficient to establish that petitioner is the father of Christian. Okay. The court has ruled that a high standard of proof is required to establish paternity and filiation. An order for recognition and support may create a situation which may be irritant to the family or the lives of the parties. So it must be issued only if paternity or filiation is established by clear and convincing evidence. We have the case of Andal versus Macaraig, a relatively vintage case, but it is still relevant because it defines what is meant by physical impossibility of access to the spouses, which is one of the grounds for challenging the legitimacy of children born during the marriage. So in this case, Emiliano was sick of tuberculosis. Okay, his sickness became worse that he became so weak that he could hardly move and get up from his bed. Now his wife Maria eloped with Felix, and both went to live in the house of Maria's father. Okay? Since Felix and Maria had sexual intercourse and treated each other as husband and wife. Okay. Emiliano died without the presence of his wife. Now Maria gave birth to a boy. Okay, now, can Mariano, the child, be considered as the legitimate son of Emiliano? You must remember that he was born during the coverture of the marriage because even though Maria lived with another man during the coverture of the marriage was still valid and subsisting. Okay. Since the boy was born on June 17, 1943, and Emiliano died on January 1, 1943, that boy is presumed to be the legitimate son of Emiliano and his wife, he having been born within 300 days following the dissolution of the marriage. Is there any evidence to prove that it was impossible for Emiliano to have such access? Is the fact that Emiliano was sick of tuberculosis and was so weak be sufficient to overcome this presumption? So the Supreme Court defined impossibility of access to include absence during the initial period of conception, which is 180 days. Okay? Impotence, which is patent, continuing, and incurable. Imprisonment, unless it can be shown that cohabitation took place through corrupt violation of prison regulations. There was no evidence presented that Emiliano was absent during the initial period of conception. There is enough evidence to show that during that initial period, Emiliano and his wife were still living under the marital roof. There is neither evidence to show that Emiliano was suffering from impotency, patent, continuous, and incurable, nor was there evidence that he was imprisoned. So the presumption of legitimacy was upheld. Okay. We have also the case of Makadangdang versus Court of Appeals. Okay. The issue in the case of Makadangdang is whether or not the wife may file an action that would bastardize her child without giving her husband, the legally presumed father, an opportunity to be held. Remember the provision that even if the wife has declared against her child's legitimacy, if the child is born within the marriage of the parents, that is not one of the grounds for impugning, challenging the legitimacy of said child. Okay. So the Supreme Court said what should really matter is the fact that during the initial 120 days of the 300 which preceded the birth of the child, no concrete proof was presented to establish physical impossibility of access. Since respondent and her husband continued to live in the same house, the fact remains that there was always the possibility of access. Okay, so the child Rolando is conclusively presumed to be the legitimate child of respondent and her husband. In order to overthrow the presumption of legitimacy, it must be shown beyond reasonable doubt that there was no access as could have been enabled the husband to be the father of the child. Sexual intercourse is to be presumed where personal access is not disproved, unless such presumption is rebutted by evidence to the contrary. Where sexual intercourse is presumed or proved, the husband must be taken to be the father of the child. Okay, so whoever alleges the illegitimacy of a child conceived during the marriage must prove the same through any of the grounds stated under Article 170, okay, and absent proof of impossibility of access, then the presumption of legitimacy will prevail. The separation between the spouses must be such as to make sexual access impossible. The policy of the law is to confer legitimacy upon children born in wedlock when access of the husband at the time of conception was not impossible. So firm was this presumption that it cannot be rebutted unless the husband was incapable of procreation or was absent beyond the 4 seas, that is, absent from the realm during the whole period of the wife's pregnancy. Okay. We have the case of Howe versus Court of Appeals. Okay. In this case, the Supreme Court said that analysis of blood samples cannot be considered as conclusive evidence of paternity. It can be conclusive evidence of non-paternity, but it is not competent evidence of paternity. Okay, science has demonstrated that by the analysis of blood samples of the mother, the child, and the alleged father, it can be established conclusively that the man is not the father of the child, but group blood testing cannot show that the man is the father of a particular child. So it is conclusive evidence of non-paternity, but it is not competent evidence of paternity. Okay? The fact that the blood type of the child is the possible product of the mother and the alleged father does not conclusively prove that the child is born by such parents. Okay. Now, we now go to the cases, okay, wherein there is a development in jurisprudence regarding the challenge to paternity of children which were conceived during the coverture of the marriage of parents. Remember, in the previous cases that we have discussed, we have learned that the right to challenge the paternity of the said children belongs only exclusively to the father and in certain exceptional cases, heirs. The mother, the child, okay, and other people for that matter cannot bring or challenge the legitimacy of a child conceived during the coverture of the marriage because such right was exclusively reserved by law to the father or his heirs. Okay. Let us now go to the case of Santiago versus Fornacion. Okay, the Supreme Court in this case said the age-old adage that maternity is a matter of fact, while paternity is a matter of faith, might not always ring true today in view of the scientific advances establishing filiation. So we have this case wherein Bernie, okay, the biological father of Sophia, filed uh, an action. He claimed to be the biological father of Sophia. He averred that Sophia was the fruit of his relationship with Magdalena, since Magdalena was still legally married to Romel, and to save Magdalena from shame, Romel was registered as Sophia's father. Thus, Sophia's last name was Hornacion, taking after Romel. Okay, now, what Bernie filed was a petition for correction of entry under Rule 108. So he wanted to change the certificate of live birth of Sophia to reflect that he was the father and not Romero. Okay? Now, uh, can this be done? Okay, the Supreme Court said, while scientific proof is allowed to impugn legitimacy under 166, the same type of proof should also be allowed to establish filiation. So you must remember that this is a case not to impugn the legitimacy of Sophia, who was born within the marriage of Magdalena and Romel's marriage. Okay. What Bernie filed is a petition to correct the entries in the certificate of live birth of Sophia. In other words, an action to establish filiation. Now, the Article 166 provides for scientific grounds to contest paternity or to contest the legitimacy of children born during the marriage. So the Supreme Court said the same proof should also be allowed to establish filiation, meaning the relationship of uh, the child to the father. It contends that an action to impugn legitimacy should be brought by the father. Okay? And that Bernie's petition is a collateral attack on Sophia's legitimacy. Now, how did the Supreme Court resolve that issue? Okay. To hastily dismiss a petition to establish filiation merely because Articles 170 and 171 only allow the husband or his heirs to impugn the child's legitimate status, unjustifiably limits the instances when a child's filiation with his biological father may be established. It was never the intent of Congress to elevate the presumption of legitimacy to a position higher than a proven fact. Every reasonable presumption must be made in favor of legitimacy, but upholding such presumption despite the absence of a contrary scientifically proven fact becomes unreasonable, if not totally absurd. The presumption that a child born in wedlock is legitimate is only a disputable presumption. This presumption may be overthrown by biological or scientific proof. So the presumption that children born in wedlock is legitimate is only a presumption provided by law. So scientific proof, okay, if introduced, okay, establishes the the filiation of the said child, okay, should deserve to be given much more weight and should replace the presumption. So if there is glaring evidence to the contrary, then the the presumption must give way to evidence, to concrete evidence. We are aware that establishing Sophia's illegitimacy would change her status from illegitimate to an illegitimate child. However, an unbending application of the provisions governing legitimate children results in preventing a child from establishing his true filiation. Okay. To cling on archaic views of protecting the presumed legitimate father from scandal and ridicule, which the infidelity of his wife produces, blindly rejects the possibility of scientific evidence proving a biological father's filiation with their child simply because the presumed legitimate father refuses to question his paternity. The court is aware that the presumption of legitimacy prevails, even if the mother may have stated otherwise. However, such rationale may disregard the state's policy of protecting the best interests of children. The presumption meant to protect the child should not be used to defeat the. Okay, so because in this case, the biological father had the capability of supporting the child. Okay. Filiation proceedings are filed not just to adjudicate paternity, but also to secure legal rights such as citizenship, support, or inheritance. Okay. The circumstances justify the need to harmonize the provisions on filiation in cases where the presumption of legitimacy is applied. Okay, so another case, which is 2022 case, Siap versus Siap, is similar to Santiago versus Arnacion or Nacion. Okay, so in this case, children who enjoy the presumption of legitimacy under Article 164 of the Family Code may impugn this presumption to any of the grounds provided under Article 166 of the same code. Okay, so in other words, there is a development in jurisprudence. It is not only the father or his heirs who are given the right to impugn the legitimacy of children born during the marriage, but the children themselves, okay, who enjoy the presumption of legitimacy may also impugn this presumption through any of the grounds provided under Article 166 of the Family Code. Okay, so in this case, Luella and Josie filed a complaint for partition and accounting. They alleged that Diosdado died and that Diosdado left as heirs his wife, Almeda, and their marital children, Josie et al., and an acknowledged non-marital child, Luella. Now, Luella and Josie discovered that a portion of the estate of Diosdado has been extrajudicially partitioned among Almeda, Harty, and Diosdado Jr. Now, Almeda maintained that Josie's real name is Josie Joy Villanueva Saavedra, whose parents are Manuel Saavedra and Lagrimas Villanueva. They claim that Luella's father is not Diosdado, but a certain Bernardo Lumahang, to whom her mother was Matilde Lusterio, was married. Okay. This court notes that petitioner does not deny that she was born during the subsistence of her mother's marriage with Lumahang. Under the family code, a child conceived during the marriage shall be presumed legitimate. Accordingly, petitioner is the marital daughter of Lusterio and Lumahang. However, the presumption of legitimacy may be refuted and overthrown by substantial and credible evidence to the contrary. This court found it illogical to adhere to the presumption of legitimacy despite considerable evidence to the contrary. The theory that only the father is affected by the infidelity of the wife no longer holds true. The circumstances under which these children are conceived and born have an impact on their rights and privileges. Filiation proceedings are filed not only for the purpose of determining paternity. These proceedings are also filed to secure a legal right associated with paternity, such as citizenship, support, or inheritance. In this case, it would be antithetical to the best interest of the child should the petition be denied based merely on the archaic view that only the husband is directly confronted with the scandal which the infidelity of his wife produces. Before petitioner may establish her filiation with the decedent, it is imperative that she first overthrow the presumption that she is Lusterio and Lumahang's marital daughter. Once the presumption of legitimacy has been successfully impugned, only then can the paternity of the husband be rejected. Okay, even if we agree that Lumahang and Lusterio had briefly separated, separation alone is insufficient to impugn the presumption of legitimacy. It is imperative that there be proof of impossibility of sexual union. The presumption may be overthrown when it was proven that for biological or other scientific reasons, the child could not have been that of the husband. So it is already settled now with the cases of Santiago and Yap. It is already settled that the right to question the legitimacy does not only belong to the husband or his heirs. Okay, the child himself can question his own legitimate filiation, okay, using any of the grounds provided under Article 166 of the Family Code. Okay, so that is all for today. Thank you for listening.